Attorney General, you have 10 more minutes of full speaking time available to you.
Thank you very much, Madam Speaker. Madam Speaker, when I addressed this Honourable House on the 5th of June, I had just concluded my review of the bill which is before this House and the sections of the bill dealing with initial hearings. I move now to clauses 20 through to 37 of the bill, which deals with sufficiency hearings under the fast-track trial law. Madam Speaker, clause 20 of that bill does a number of things, but in particular, it removes, among others, references in subsection 6.2, subsection 1, where the Director of Public Prosecutions would now be subject to a sufficiency hearing. As mentioned earlier in my presentation, this bill proposes that the accused will be subject to a sufficiency hearing, even in circumstances where the Director of Public Prosecutions files a voluntary bill of indictment. The rationale, Madam Speaker, is balanced to ensure that while the Section 90 powers of the DPP are upheld, sufficiency of evidence is still to be assessed. Among other things, Madam Speaker, that part of the bill that we speak of, Clause 21, would insert after Section 19 a new Section 19A, which will deal with witnesses and witness statements as it pertains to a sufficiency hearing. It now proposes that the attendance of a witness shall not be required at a sufficiency hearing unless, on application, the master makes an order for the attendance of a witness who filed an unsworn statement. This, Madam Speaker, is a pivotal change to the way pretrial proceedings are conducted, remembering throughout my earlier presentation and this presentation that we are about expediting the process of the pretrial phase of trials of accused persons. The addition of oral evidence by way of further evidence and cross-examination has been identified as a major cause for the protraction of preliminary inquiries, which this bill seeks to abolish. Clause 23 of the bill will amend Section 21 of the Act, Madam Speaker, in subsection 2 by deleting certain paragraphs, C and D, and substituting new paragraphs to ensure that there is clarity in procedure as it relates to the admissibility of prosecution witness statements. Among other things, Clause 23 will also delete paragraph DA in Section 21.4 and substitute a new paragraph DA in order to clarify the procedure as it relates to a statement made by a person who does not speak fluent English. Additionally, this clause would amend Section 21.5 by repealing it and amend Section 21.8 by repealing and substituting a new Section 21.8 which pertains to a transcript of proceedings and evidence obtained under a treaty to be admissible as evidence at a sufficiency hearing. Madam Speaker, Clause 24 of the bill will amend Section 23 of the Act by deleting paragraph B, substituting a new paragraph B to clarify the procedure and provide for the Criminal Procedure Act relating to orders under Section 25 concerning a master's final decision at a sufficiency hearing. Clause 25 of the bill will amend Section 24 of the Act by inserting in subsection 1 the words "on the indictment," which concerns discharge of the accused. The clause also repeals sections 4 to 11 of Section 24 of the Act and substitutes it with the new subsections 4 to 6. In order to allow the Director of Public Prosecutions to appeal the decision of a master if the former is of opinion that the accused ought not to have been discharged. It also allows for the appeal of a master decision to the Court of Appeal in accordance with Section 65C of the Supreme Court of Judicature Act. Then clauses 26, 27, and 28 through to 30 make for further substantive amendments, Madam Speaker, of the Act. Clause 31 of the bill will amend Section 27 of the...
Just a minute. Please leave the chamber and get your device under control. Thank you. Attorney General.
Thank you, Madam Speaker. Clause 31 of the Act will amend Section 27 of the Act by repealing Section 27. This effectively removes Schedule 6 matters which were exempted from this charge. This is better aligned as the indictment is now being filed at the beginning of the sufficiency hearing process, so there is no longer a need to have a schedule which exempts matters from discharge due to delayed filing of the indictment. Clause 32 of the bill will amend Section 28 of the Act by deleting paragraph C of Section 28, inserting a new subsection 1A to account for where master is referred an accused to a judge for sentencing following an early guilty plea, and the Director of Public Prosecution is to be given notice of that referral. There are other substantial amendments that are proposed, Madam Speaker, to expedite the fast-track trial process in the currency of the sufficiency hearing. Clause 36 of the bill will amend Section 29(2)(b) of the Act by allowing the oath of a credible witness whose attendance is not reasonably practicable as a result of being outside of Trinidad and Tobago to be secured physically or by electronic means. The clause will also amend Section 29 of the Act by repealing Section 29(7). Then there is, importantly, Madam Speaker, Clause 39 of the bill, which will amend the Act by inserting after Section 32A a new Section 32B to deal with anonymization of documents for a variety of reasons. For example, the protection of witnesses. Importantly here, the original version of the document is always retained for court and internal purposes. Madam Speaker, Clause 40 of the bill will amend the Act by amending Section 33(2) by deleting the words, "Neither the prosecutor nor the accused elects to have the case determined in accordance with this Act," and substituting the words, "No order is made under Section 32A," in order to allow for savings under the Indictable Offences Preliminary Inquiry Act. Clauses 41 through to 44, Madam Speaker, address the ability of the Chief Justice to produce practice directions to make amendments to the schedules. And finally, Clause 45 of the bill, Madam Speaker, deals with consequential amendments as a result of the Act, namely the Summary Courts Act, Chapter 420, the Criminal Procedure Act, Chapter 1202, the Criminal Procedure Change of Venue Rules, the Police Service Act, and the Family and Children Division Act. Madam Speaker, what is very important to appreciate about this bill, which is before this House, is that it complements a host of reforms which have been undertaken over the past 8 years and work in tandem with those to reduce the delays associated with the pretrial process in criminal matters. We can note some measures: backlog identification at all levels of the court and prosecutorial division.
Attorney General, you have 2 minutes left.
Thank you, Madam Speaker. The creation of divisions of court and a number of other significant amendments that have been passed by this government, including the creation of a public defender system and generally the implementation of a fully computerized case management structure. May I indicate, Madam Speaker, as I close, that I will be moving an amendment to Section 5 of the bill, which is the Act, which is before this House, to ensure that due process will be ensured in relation to search and seizure, so that by that amendment, all persons whose premises are searched and seized will be subject to the oath which the magistrate, the master, will be required to take from the witness. And may I say finally, Madam Speaker, that the object of this bill, even without requiring, is legitimate. It is legitimate in its aim, it is proportionate, and is indeed necessary. And I look forward to hearing my learned colleagues' contributions on this very important piece of legislation designed to enhance our criminal justice system to provide for a speedy and expeditious trial process. With respect, Madam Speaker, I beg to move.
Honourable members, I shall